All right, buckle up because this is not one case. It's a full courtroom gauntlet. In the next few minutes, you're going to watch Troy Vincent Jr. plead guilty to evading arrest with a vehicle, Trayvon Alexander take a plea on a murder charge, and Logan Eaglin gamble big by rejecting a deal while the judge lays out a brutal habitual offender punishment range. Then we pivot to probation drama. Marissa Fortune gets a rare second chance with conditions. Wayne Cummings faces a bond fight while accused of a new DWI on a manslaughter probation, and Marquise Jones watches deferred probation turn into real time. Pay attention to the judge's wording those rights you're giving up lines. That's where the real consequences hide. Who do you think is taking responsibility here? And who's just trying to survive the system?
Okay. All right. And so will Mr. Vincent waive the formal reading of the indictment?
He does, Judge.
And so are you Troy Vincent Jr.?
Yes, ma'am.
And Mr. Vincent, in cause number 25 DCCR 0384, the state's elected to proceed on count 1 only. It alleges you committed the third-degree felony offense of evading arrest or detention with the use of a vehicle from February 11th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Vincent is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty in count 1 of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, sir. You can go back with the bailiff.
Thank you, Judge.
Thank you. Good morning. Are you Trayvon Alexander?
Yes, ma'am. Good morning.
Good. And Ms. Perazo, will your client waive the formal reading of the indictment?
Easily, Your Honor. That's not for this.
Mr. Alexander, in cause number 25 DCCR 0831, you're charged with a first-degree felony offense of murder from May 13th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Perazo?
Yes, ma'am.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am. She explained it.
Okay, good. And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Understood.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Alexander is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the first-degree felony offense of murder. Sentence you in accordance with your agreement to a term of 30 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also have handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Perazzo. All right, good luck to you, sir. You can go back with the bailiff. Good morning, you're Logan Eaglin?
Yes, ma'am.
Mr. Eaglin, in cause number 25, DCCR 0897, and we've gone over this before, but I'm going to go over it, make sure we're all on the same page and you understand everything. In that case, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that's from October 26th of 2024. Your indictment alleges that you were previously convicted of burglary of a habitation, March 1st of 2013 in two different cases of burglary habitation on that date. And then on September 3rd of 2015, you were also convicted of prohibited substance or possession of a prohibited substance in a correctional facility. What that means is if you go to trial and you're found guilty in this case, and those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on count one only, just the aggravated assault case, with a cap of 20 years as your punishment, which means you would be leaving your punishment up to me. I can give you 20 years, I could give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and have a jury decide your case. I just want to make sure you understand the possible consequences if you go to trial and what your options are. You understand all of that?
Yes, ma'am.
And you want to reject this and go forward with your trial, is that correct? All right, is there any evidence or discovery that hasn't been turned over that you guys are waiting on?
Not that I'm aware of, Your Honor.
So I will set it on the next available trial docket. Everybody will be prepared for trial, and we'll get your case tried as quickly as possible. You can go back with the bailiff. Good morning. Are you Marissa Fortune?
Good morning. Yes, ma'am.
And Ms. Fortune was previously in court, entered plea of guilty in cause number 25 DCCR 1117 to the new offense of credit or debit card abuse, and then entered pleas of true in cause number 24 DCCR 1156. It was a motion to revoke probation. And the agreement was for a 5-year deferred on the new case to continue her on probation, and in each of those cases for her to be ordered to enter and complete the cognitive track of the ISF program, correct?
That's correct.
In addition, there was restitution in the new case, but I don't
The
see
victim
an
himself,
amount.
it was a credit card.
$301.66.
It was a credit card. The victim was not charged that, so that would be between the credit card company,
Okay,
if they were actually out. And I haven't heard anything from them.
you have not heard anything from the credit card company, then I'm not going to order it. That just makes it more confusing, I think. Have you heard anything or, okay, thank you, ma'am, and thank you for being here. All right, then, I have received that pre-sentence report, reviewed it, and the update. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes.
Any additions or corrections?
No, Your Honor.
Nothing, so
Okay, so Ms. Fortune, you're going to be given an opportunity today that you likely will not get again, okay? So I want you to take advantage of this. Everybody's willing to work with you, get you the help you need so that you can be successful on both of these probations. But I want to make sure you understand that if you're back in here on a motion to revoke on these cases, it is very likely that you will be found guilty in each of these cases, become a convicted felon, and end up in prison. Okay? Yes, ma'am. So I'm going to find in cause number 25 DCCR 1117 that you entered that plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but at this time I'm going to follow the agreement that you made and defer all proceedings and place you on probation for 5 years. You're ordered to follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. And then in cause number 24, DCCR 1156, I'm going to find sufficient evidence to revoke that probation, but I'm not going to do that. I'm going to continue you on that probation and modify the conditions of it to include that you enter and successfully complete the cognitive track of the ISF program. Again, you do all of this, you're going to be given the tools that you need to be successful, and if you don't take advantage of it, you won't be leaving me many choices. You understand? I'm going to hand you in each of your cases, excuse me, the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. All right, good luck to you, ma'am. You can go back with the bailiff. Are you Wayne Cummings? Mr. Cummings, the best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. And so this is cause number 18-29640. Mr. Cummings is on probation for the offense of manslaughter. A motion to revoke community supervision has been filed, and Mr. Kimler's filed a motion asking that I set a bond. Looks like the date of the probation was from October 22nd of 2018. A 10-year term in prison, probated for 10 years. New offense alleged in that motion is a driving while intoxicated, October 5th of 2025 in Orange, at a location other than his residence at 4:15 a.m. on October 5th in Orange, and that he was intoxicated on that date and behind in court-assessed fees. Mr. Kimler, you may proceed.
Your Honor, first observation is Mr. Cummings did turn himself in. This wasn't one where he headed for the tall grass when he found out he had an MTRP. He did turn himself in. I understand, I think this is straight probation. It's not entitled to a bond. However, with the Orange, and of course, Mr. Smith is familiar with Orange County. It may be a while before that DWI is filed, so I don't know how long it's going to take for the state to be in a position to try to prove that up. So we were just asking for a bond pending this position if they're going to proceed on the DWI. Obviously, they could proceed on the administrative violations.
Mr. Smith?
My concern, Judge, is firstly, the manslaughter was basically a DWI where he hit somebody and killed them. He had issues. Safety was a recommendation for the original probation to go through in the PSI. This new offense, the allegations apparently show he was out at 4 in the morning and was intoxicated driving. And so I would have reservations and concerns. I think there's been a relapse, and he's not actually entitled to a bond because it's a straight probation versus a deferred. So we would be opposed to a bond.
Do you know the status of the Orange County case?
I don't, Judge.
I don't think it's been filed yet, 100%. I checked before.
If it was just knowing how they work over there, if it was just alcohol, they would have already probably had the results.
Y'all are just guessing. Is there a way for us to find out? Is there any kind of hold on him? Yeah, let's do real quick, and we'll just do it real quick. Just have a seat, sir. And there's not. I'd like to know what the. Good morning. Are you Marquise Jones? Yes, ma'am. And Mr. Parker, will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Jones, in cause number 21-37263, I have a motion to revoke your unadjudicated probation shows that you were placed on probation February 23rd of 2022 for the offense of theft of material, and that was a state jail felony, and it was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of evading arrest on June 20th, 2024 in Harris County, Texas. And is that true or not true? And then count 2 alleges that you were at a location other than your residence at approximately 1:30 a.m. June 20th of 2024. And is that true or not true? Did you enter your pleas of true to counts 1 and 2 freely and voluntarily? And did you plead true to those counts because they're actually true? Speak up, please. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
And I think I said your plea of guilty instead of true, but your pleas of true. Anyway, all right, so I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty. And at this time, find you guilty of theft of material, aluminum. I guess it goes on, aluminum, bronze,
Aluminum,
copper.
bronze, copper. They were cutting catalytic converters.
And so find you guilty and sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir, and thank you for being here, sir. Oh, my nose is sneezing.
So here's the big picture. Multiple defendants, multiple outcomes, but the same theme every time pleas and probation come with strings. Troy gets 2 years on an agreed plea. Trevon takes 30 years on a murder plea. Logan rejects a capped offer and risks the brutal, habitual offender range if convicted. Marissa gets a major second chance with deferred probation and program requirements. And the judge avoids messy restitution without clear proof. Wayne's bond issue highlights public safety fear when a probationer faces a new alleged DWI, and Marquise shows how pleading true can turn deferred status into a conviction in 15 months in state. Jail plus those repeated warnings about appeal waivers and firearm restrictions. Now tell me which ruling felt most fair and which felt the harshest. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns.